Every day in the USA, people find themselves in court.
We now call 21-38247, the state of Texas versus Eric Wade Weisenbecker. Is that you?
Yes, sir.
Present with your attorney, Mr. Matuska, and the state's attorney. All right, you were charged here with the first-degree felony of continuous sexual abuse of a child. What are we going to do?
It's a plea on the lesser of aggravated sexual assault of a child under 14, Judge.
All right, so what is it? You said it's aggravated sexual assault, right?
Yes, sir, of
Oh.
a child under 14, and I can give you the code citation for that. Second here.
22.021, if you need it. All right, does the defendant waive a formal reading of this? Again, can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that from on or about October 29, 2014 through on or about October 31st, 2019 in Jefferson County, Texas, you committed the first-degree felony of continuous sexual abuse of a child. Do you understand what you were charged with in this indictment?
Yes, sir.
Now, an agreement has been reached where you would be pleading guilty to the lesser included offense of aggravated sexual assault of a child. Is that your understanding of the agreement?
Yes, sir.
And in other words, you would be pleading guilty to under section 22.021 of the Texas Penal Code, aggravated sexual assault. A person commits an offense if the person intentionally or knowingly, regardless of whether the person knows the age of the child at the time of the offense, intentionally or knowingly causes the penetration of the sexual organ of a child by any means, or causes the sexual organ of a child to contact the sexual organ of another person, including the defendant. And those two ways, those two manners and means are alleged in this indictment.
And then also, Judge, just to make sure that you got the finding there, you need to be almost at the very bottom. The child has to be under 14.
And it's alleged in this indictment, though, that the child was then and there younger than 14 years of age.
Yes, sir.
At the time of the event alleged in the indictment. An offense under this section is a felony of the first degree. And is the punishment range a minimum of 25 years imprisonment?
No, sir, not on the offense that he is pleading to. It is on the offense that he is indicted. The offense that he is pleading to is just a standard first-degree felony with special parole rules because of the child being under a certain age.
All right, let me just get this clear here. So he's going to be pleading guilty to the lesser included offense of aggravated sexual assault under section 22.021. So this then becomes punished as a first degree felony, which means you face no less than 5 nor more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand, sir?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 25 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to this lesser included aggravated sexual assault under section 22.021 of the continuous sexual abuse of a child under section 21.02, as you are originally indicted, this first degree felony of the lesser included offense of aggravated sexual assault under subpart A, which a person commits an offense if the person intentionally or knowingly, regardless of whether you knew the age of the child at the time of the offense, caused the penetration of the sexual organ of the child by inserting your finger, and did then and there intentionally or knowingly cause your sexual organ to contact or penetrate the sexual organ of the child. The child was younger than 14 years of age at the time of the event, which constitutes the elements of this lesser included first degree felony of aggravated assault. Is all of that true and correct? And is that what you were pleading guilty to?
Yes, sir.
Are you doing
Aggravated sexual assault of a child, Judge.
sexual assault of a child?
Yes,
Well,
you said aggravated assault.
aggravated sexual assault.
Yes, sir.
And are you doing that voluntarily, knowingly, intelligently, and because all of this is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did
Yes,
you
sir.
understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence without objection admitted. This states, among other things, you were mentally competent to enter your plea, which is being made freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You understand it fully. You were guilty of the lesser included offense of sexual assault of a child, aggravated sexual assault of a child under this indictment of continuous sexual abuse of a child. You were giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement. And anything else to add?
No, sir.
If not, I'm going to find, sir, you are pleading guilty again to this lesser included offense of aggravated sexual assault of a child, of first degree felony offense, voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 25 years. Do you understand what has happened today, sir?
Yes, sir.
Now, one other thing is you now have been convicted of an offense which requires sex offender registration admonishments and the sex offender registration requirements under the Texas Code of Criminal Procedure in Chapter 62. Do you understand what you are going to be required of, sir?
Yes, sir.
Ryan, I'm going to write your name here on the sex offender to complete it. It says that you acknowledge that you've been admonished by Mr. Matuska that one, with a reportable conviction or adjudication, like what has happened in this hearing, which requires you to comply with Chapter 62 of the Texas Code of Criminal Procedure, sex offender registration, what we refer to it as. Failure to do so properly is a criminal offense and may result in prosecution. Do you understand?
Yes, sir.
Furthermore, if you move to another state that has similar reporting requirements for sex offenders, you must register in that state. And failing to register would result in you being charged with a criminal offense. Do you understand?
Yes, sir.
Do you understand what has happened today, sir?
Yes, sir.
Anything else to add on this?
No, sir.
Anything, Brian? Okay, that is all. We're in recess on this case.
Thank you, Judge.
Hold on. All right, in this case, the defendant has pleaded guilty and has been sentenced to 25 years imprisonment for continuous sexual. It was the lesser included.
Yes, sir.
Aggravated sexual assault under this indictment, charging him with continuous sexual assault of a child. Under Article 42.03 of the Texas Code of Criminal Procedure, the court shall permit a victim of an offense to appear in person and to present to the court and to the defendant a statement of that person's views about the offense, the defendant, and the effect of the offense on that victim. And you may proceed.
Thank you, Judge.
I asked myself many times why I could do that to someone. Why could you put the time on your day to hurt me? I even asked Papa why you would do that, and he would tell me because he was lonely, didn't have a girlfriend and a job. He only sat on his butt and played video games and smoked weed, and he was lonely, and you're the only female I was with him, so he did that to you. For the longest time, I wouldn't accept that answer because I didn't want it to be true. I wanted it to all be an illusion, but I came to terms and accepted that it is true. It's not my fault. You're the reason we're here. You know, when I first told someone, you tried to tell me for a longer time that it was the drugs and that it didn't happen, that I was just trying to get you in trouble. But I'm doing this right now to heal from the trauma that you have caused me and from the hurt that you have caused me and how I react to other people. And I forgive you, but I don't forgive the action that you've caused.
What, hold on. Did the defendant speak?
Yes, sure.
You speak to her during her time of allocution, I will hold you in contempt and add more time to your sentence.
Yes.
Is rudeness a part of your character as well? Well, remain quiet. She has the floor. The law says she is entitled to speak, not you. Follow the rules.
No, that's my fault. I should have.
That's all right. He made a free choice to attempt to dialogue with the lady, and that is not allowed under the rules. Go ahead, ma'am.
That's all we have, Judge.
Is that it?
Yes, sir.
Yes. Anything else you'd like to add?
I still love you because you're my dad, but I don't love you as a person anymore.
Ma'am, just do your best to move on with your life. The world has wonderful things to enjoy and take advantage of. And sometimes all of us have to deal with an evil situation that comes in front of us. We didn't expect it. We don't deserve it, but it's part of life sometimes. Do your best, please, to, try to put that past you and enjoy the good, wonderful things that life has and make the most out of that. Okay. Good luck to you. Thank you.
Thank you, Judge.
Yes. That is all.